Yes.
is on 11th August 1952, soon after the Delhi Agreement in July 1952. And in PDF 562 at 1921, he then explains why the provision is temporal. Here I would like to point out, my lords have that paragraph?
Page?
Page 1921, PDF 562.
But after that, actually, we were reading at it goes on to about 1466, where he specifically speaks about the importance of the affiliation with India and accession to India. Because he speaks in terms of, first he speaks about the Indian Constitution.
That's correct.
Second, it's very important from a historical perspective. Sheikh Abdullah refers to the land reforms which were taking place post the First Amendment and the other amendments which took place to the Constitution. He says Pakistan, on the other hand, is a feudal state.
That's correct.
And therefore, our interests would not be protected in a feudal Pakistan as compared to an India where land reforms were taking place. Then he refers to the fact that, India has, of course, the access to the seas and therefore a better, as an economic powerhouse for us to carry on trade through the auspices of India. And this really continues until PDF page 107.
I didn't want to refer to it because it would take too long. Two, it's the background, but we are dealing with a temporary provision. That's why I didn't refer to it. But all that is very important. The reason is simple. Ultimately, what did J&K do? The people of J&K gave to themselves the constitution just as the people of India gave to ourselves this constitution. So central to all this is the will of the people. And therefore, you'll have to compare it to the...
Very interestingly, see how Sheikh Abdullah puts it. He says the most powerful argument which can be advanced in her favor is that Pakistan is a Muslim state.
Yes.
And a big majority of our people being Muslim, the state must succeed to Pakistan. But then he says, this claim of being a Muslim state is of course only a camouflage. It is a screen to dupe the common man so that he may not see clearly that Pakistan is a feudal state in which a clique is trying by these methods to maintain itself in power.
Absolutely. She is right. The point I'm making, Mullahs, ultimately, what's the essence in this matter that your lordships are hearing? The will of the people of a state where the Executive Act of the Union of India, which decimates the will of the people. That's the issue before you. That's what your lordship, because all the three acts of the Union of India are executive acts. 356 deletes the proviso of Article 3. That's an executive act.
Mr. Sibal, look at the foresight of the speaker. He says, these days, economic interests and a community of political ideals more appropriately influence the policies of state.
Absolutely, absolutely.
He had this vision in 1951 when he was speaking about the importance of economic interest, which is what the world is talking about today.
Absolutely.
In a globalized world.
And in that situation, the ruler had no choice. Absolutely no choice. So, the point I was making is that we are now dealing with three executive acts. One, the 356. Two, change of interpretation in the definition of Constituent Assembly under 367(1). And the abrogation. These are all executive acts. The will of the people is not considered at all. That's the question. Can you delete provisions of the Constitution by an executive act? Can you decimate the Constitution by an executive act? Can you change the Constitution by an executive act? We're not talking about legislation here. We're not talking about parliamentary legislation. That comes after these executive acts, mullahs, are implemented. That's the question. That's the... You can't change the Constitution of India as applicable to Jammu and Kashmir by deleting Article 3, the proviso to Article 3. You can't do that through an executive act. You can't change the definition, Malaj, of the legislative, of the Constituent Assembly as Legislative Assembly through an Executive Act. Then I'll come straight away to the issue, Malaj, 1921.
1921.
Yes, PDF, Malaj, 562.
Yes, volume? Which volume is this, Mr. Sibal?
Same volume, Malaj, same volume.
Volume 7.
Yes, same, Malaj, the same speech, Malaj, comes a little later.
19.
Sorry, same speaker comes a little later, Malaj. 11th August is the speech. Yeah.
1921. PDF page 562.
562, PDF 562. All my lords have it, I'll read it. Here I would like to point out that the fact that Article 370 has been mentioned as a temporary provision, the Constitution does not mean that it is capable of being abrogated, modified, or replaced unilaterally. Kindly mark the words unilaterally, which is exactly what has happened. In actual effect, the temporary nature of this article arises merely from the fact that the power to finalize the constitutional relationship between the state and the Union of India has been specifically vested in the Jammu and Kashmir Constituent Assembly. That's how Malaj's Parliament understood it in 370. That's how the state understood it. It follows that whatever modifications, amendments, or exceptions that may become necessary, either to Article 370 or any other article in the Constitution of India in their application to Jammu and Kashmir, are subject to decisions of this sovereign body. Since a good deal of confused thinking and uninformed criticism is indulging us in the interest of, I would like to point out here that the Constitution has confined the scope and jurisdiction of the Union powers to the terms of the instrument of accession, with the proviso that they may be extended to such other matters also as the President may by order specify with the concurrence of the Jammu and Kashmir Constituent Assembly. The special problems facing the state were thus taken into account, and under the Constitution, the relationship approximated to that subsisting under the instrument of accession. The Constitution of the Indian Union therefore clearly envisaged the convening of a Constituent Assembly for the state of Jammu and Kashmir, which would be finally competent to determine the ultimate position of the state in respect of the sphere of its accession, which would be incorporated as in the shape of permanent provisions of the Constitution. This briefly is the position which the Constitution of India has accorded to our state. I would like to make it clear that any suggestions of altering arbitrarily the basis of our relationship with India would not only constitute a breach of the spirit and letter of the Constitution, but it may invite serious consequences for a harmonious association of our state with India. The formula evolved with the agreement of the two governments remains as valid today as it was when the Constitution was framed, and reasons advanced to have this basis changed seem completely devoid of substance. In arriving at this arrangement, the main consideration before our government was to secure a position for the state which would be consistent with the requirements of maximum autonomy to the local organs of state power, which are the ultimate source of authority in the state while discharging obligations as a unit of the federation. Then let us kindly come PDF 648. This is Mir Qasim's statement on 10th November 1952.
Okay.
And this is exactly what I've been submitting before your lordships from day one. A unilateral executive decision cannot change the terms of a relationship which are constitutionally embedded in Article 370. ठीक है. Whereas PDF 648, page 2007. This speech was given by Mir Qasim on 10th of November 1952. In the statement of the Sheikh Mullah, that discussion on his statement continues. Whereas in the middle of that paragraph, starting, it is said that the accession of Kashmir with India should be, as far the statement is concerned, there can be no denying the fact that it should not be a dynamic in the sense that we give up our principles. On the contrary, accession should help us in achieving ideals and preserving our autonomy, except, of course, in the objects we handed over to India. Our assembly is competent to make laws and decide the issues, if any, since we are enjoying complete autonomy. We can even frame and amend our constitution. In this collection, we have application under connection. It should be with the application order of 1950 of the Indian Constitution. According to this order, all these powers do not vest in the state. Now, the next is important. We want to develop Kashmir according to the program of New Kashmir. Some people say that it is just possible that in future Kashmir may also become a part of India like any other state and get merged with it. In that case, our internal economy will be reduced to naught and residuary powers will be snatched from us. In this connection, I will submit that the thinking of such people is morbid. These are the vested interests which create such misunderstandings. The representatives of the government of India have not kept any time limit for these residuary powers. This is important. That's why Malas 370 talks about instrument of accession and the items in the concurrent list, but doesn't talk of list 2, which are the residuary powers of the state. Therefore, there should be no room for such doubts. We have acceded to India with a definite objective, and I am sure the objective will be achieved. Some interested persons are creating misgivings as regards the autonomy and say that Kashmir has been granted autonomy simply to benefit its Muslim population. But this is a baseless allegation. If the people from outside are not given the right of acquiring property in the state and getting recruited to state services, then it was not the Muslims of this place alone would get benefit, but all communities will also get benefit. Then let us kindly come to the social system which will be set up according to the program in New Kashmir will provide equal opportunities of development to all citizens of the state, be they Kashmiris, Ladakhis or Dogras. Now let's skip the rest.
690.
PDF page 694 now.
Formulate, now that we've seen the speeches, we'd like to formulate the principle which
The principle is, Madas, that an executive act of the Union of India cannot alter unilaterally provisions of the Constitution of India as applicable to the state of Jammu and Kashmir. That's the central.
cannot alter unilaterally
Yes.
the provisions of the Constitution
Of India as applicable to the Jammu and Kashmir, including getting rid of the special status given, acceded to by the Union, by the Government of India, and by Parliament in enacting 370 of the Constitution. That's the submission.
Say it's an executive act.
I'll say 356 is executive, 367 definition is executive. These are all executive acts. Parliament came into the picture when the changes had already been done through executive acts. We're challenging that.
As you argued, the process was wrong.
Yes.
Whatever was done. But
Yes.
that is the parliament did it.
No, Parliament accorded approval to the executive acts which unilaterally changed the constitution as it was applicable to the state of Jammu and Kashmir. That's the central question that your lordships will have to decide. Could Parliament have, could the Union of India have done it?
So is it your case that the parliament could have done it?
No, not at all. Well, that also I will answer. Well, let's kindly see. ultimately, this was a political decision taken in the context of the situation then prevailing. Right? And the complete abrogation of Article 370 must also be a political decision. Whereas your lordships will remember Brexit, what happened? In Brexit, what happened? There was no constitutional provision seeking a referendum. But when you want to sever a relationship which has been entered into, you must ultimately seek the opinion of the people. Because people are central to this decision, not the Union of India. It goes counter to the very grain of Article 370.
Mr. Sibal, in a constitutional democracy, seeking the opinion of the people has to be through established institutions.
Agree?
Right? So long as a democracy exists, as it does, in terms of a constitutional democracy,
Yeah.
any recourse to the will of the people has to be expressed and sought in terms of established institutions.
I agree. So
There's no
either
question.
you do it,
So
either you do it.
you cannot envisage, therefore, a situation like a Brexit type referendum.
Yeah.
That's a political decision which was taken by the then government.
Yes.
But within a constitution like ours, there's no question of a referendum.
But this is a political decision that they have taken by unilaterally through an executive order, changing definitions. This is not some constitutional decision. That's what your lordships, supposing your lordships were to say that they can change the definition, or your lordships were to say.
But
Therefore,
the ultimate question is whether the constitution does or does not interest that authority.
that's correct. That's all that I'm asking, Miller. I'm not asking for anything more.